Good morning.
Your Honor, may I call the case?
Would you please?
Calling docket 2484CV03009, Shannon O'Brien versus Deb Goldberg, Treasurer and Receiver General of the Commonwealth of Massachusetts. If counsel would rise and introduce themselves to the court and the record, starting with the plaintiff first, please.
Good morning, Your Honor. William Gilday on behalf of Shannon O'Brien, with me is Attorney Baxter.
Good morning, Mr. Gilday, Mr. Stern.
Good morning, Your Honor. Assistant Attorney General John Hipp, and the Treasurer and Receiver General.
Mr. Hipp, good morning. Thank you for being here. We're here to address the cross motions for judgment on the pleadings. I have obviously a thorough familiarity with the administrative record that the court's been living with for the better part of 2 years. And you can presume a thorough familiarity with everything you know. I've studied your briefs. You do not need to do an orated rendering of the arguments in your briefs, with which I'm familiar, unless you think to some extent I may have missed something in them, or to some extent you feel that the limitations on the length of the briefing did not permit you the full opportunity to make arguments that you want. I've left open most of the morning for this, so I won't interfere with you any more than I ordinarily would. Who wishes to go first?
Shannon O'Brien, Your Honor.
Fair enough.
Thank you, Your Honor. Ms. O'Brien has been a well-respected public servant for a significant amount of time in the Commonwealth. She blew the whistle on the big dig and raised the cost overruns when she was the treasurer. She's known as a change agent. That is why she was brought to the CCC. She has never faced these type of allegations in her career, that she's a racist, a bully, or creates a hostile work environment. That's because they do not exist. The court is familiar with the administrative record, and plaintiff submits that there's not substantial evidence to support the grounds for removal asserted by the treasurer, which are that she committed gross misconduct and she's unable to discharge duties. To give a little background of the complainants, the chief complainants in this case, Your Honor, who are Sean Collins and Nerys Camargo, there's ample evidence in the record that both complainants had motives to make complaints about Shannon O'Brien and remove her as the chair.
Nothing so found by the treasurer in the decision.
Of course not, but there are, like I said, there are portions of the record that show that Sean Collins was not doing a good job as a manager, and petitioner was trying to correct that as soon as she came into the CCC. He's an at-will employee. He reported to the commissioners and served at the pleasure of the commissioners. But Sean Collins took the position that he didn't. He refused to meet with Ms. O'Brien when she became chair, despite meeting with the prior chair, Mr. Hoffman, almost on a weekly basis. He didn't follow the job description that said he reported to the chair, which the treasurer found that the job description did not apply, despite there being no evidence to the contrary. And the real issue was that the agency was imploding when Chair O'Brien took over. That's why she was put in this position, to fix the agency. But in order to fix the agency, she had to hold the staff accountable, and that started with Mr. Collins. And she was met with significant resistance as soon as she took over the position. Kimberly Roy testified that staff would say, we don't answer to the commissioners, we only answer to Mr. Collins. Mr. Collins said he was a traffic cop. Everything that went up through the staff went through him to the commissioners and vice versa. So it made it very hard to hold the staff accountable. During her one-year tenure, 2022 to 2023, the general counsel left, the CFO left, and Mr. Collins was exercising his leave rights at various times. The first time he exercised his leave rights in June, the commissioners weren't informed of that. That's an issue when the executive director just takes off and nobody knows where he is. They knew he had a baby, but they didn't know how long he was going to be out or what's supposed to happen. And that's an issue under the enabling statute because of the powers and duties of the executive director. And it provides when he's not there that commissioners are supposed to appoint an acting executive director.
Now, what you're reciting, of course, are elements of the administrative record.
Correct, Your Honor.
But these are not matters of specific finding by the treasurer.
No, but I want to...
On some level, what you're doing cuts against the grain of the deference to which the findings of fact of the treasurer are entitled to.
I don't think she's entitled to deference, Your Honor, under the levy case. the SJC that this type of decision is not what deference is to be afforded. It's something
Well,
that requires.
Lenny said that she's not entitled to deference in as much as her assertions are matters of legal conclusion. Certainly the legal conclusion is not entitled to deference, and that's a matter of settled law. But we're talking now about matters of fact. And here you're reciting specific elements of the administrative record that are factual, but were not matters of express finding by the treasurer. And indeed, on some level, they cut against the grain of what the treasurer did find factually.
That is true, Your Honor, but I understand the standard to be that the whole record is at play, and the court is to take into consideration what the treasurer finds and whatever detracts from that in the record. That's why I'm providing a little bit of context about Mr. Collins and Ms. Camargo, former Commissioner Camargo. And it also leads into the argument that Treasurer Goldberg should not have acted as the fact finder in this case because she was biased because of who the complainants were, namely Mr. Collins.
You're now pivoting into the constitutional argument.
Partially, Your Honor, yes. If I could proceed with just a little bit more background on Mr. Collins. Petitioner was trying to give him an option. Either do your job and stay, or you have to leave. Before she even was at the commission, he was talking about resigning to other commissioners. He made the accusation in his demand letter to council that he was thinking of resigning only because of Ms. O'Brien, but that was proven to be untrue, at least found by the investigator Tracy Spruce. Going to Commissioner Camargo, she applied for the chair position before Ms. O'Brien did. She didn't get that job. She was upset about it. She had motive to lodge the complaint that she did against Ms. O'Brien. But Treasurer Goldberg dismissed the evidence that there was motive of these complainants. And that is the background for why her findings of fact are skewed and shouldn't be afforded as much deference as she claims it should be. Looking through the lens of her, she could not have been an impartial fact finder. One, because of her relationship with Mr. Collins prior to the Treasury and while he was at the commission. I draw your attention, Your Honor, to the October 4th notice letter that was the initial set of charges that we received from the Treasurer after a lawsuit was filed and after a petition was suspended. And on page 1005 of the administrative record, Treasurer Goldberg wrote, "My office advised you previously that commission discussions about Mr. Collins' performance should be conducted in executive session." Now, why would an appointing authority over an independent agency tell that to the chair? The treasurer has claimed that she has no oversight, no management of the commission at all. Well, why is her office reaching out about Mr. Collins and saying that his performance evaluations shouldn't be discussed in executive session? First off, that's an incorrect interpretation of the open meeting law statute, which says that a performance should be discussed in open meeting law. But the point is, why is she reaching out to the CCC and Shannon O'Brien? Going to the merits, Your Honor, we'll start with gross misconduct. The standard is not defined in the statute, we'll concede that. But the Hellman case provides a helpful analysis. That it must be intentional or reckless, clearly understood to be a wrongful act, and extremely harmful. None of that was proven in this case. Neither of the investigators found that there was intentional behavior by Ms. O'Brien. Starting with the allegations. The first one is that Shannon O'Brien used the term yellow. The context that came out at the hearing through Commissioner Roy and Ms. O'Brien is that the comment was made during a social equity meeting when Ms. O'Brien was discussing her excitement about a conversation she had with a local real estate developer about how to bring social equity to Boston. She made the comment, she repeated the comment of somebody else, talking about her excitement. Kimberly Roy said there was no racial undertones to this comment at all, and that it was in the context of her being excited. The context of the statement under the Hellman court is what is important here. She wasn't uttering a racial slur at somebody. There's a case that is cited in the treasurer's, I believe, her removal decision, how using a racial slur can be considered gross misconduct. But that is a much different case. That is where an employee called another employee a racial slur and threw an apple at her. That is not remotely similar to what happened here. But all throughout this hearing and prior, it has been fixated on the term yellow and that it's a slur and that it's associated with Ms. O'Brien. But she was talking about her excitement for social equity, how she was going to bring that to the commission and fix the failures of the commission in not fulfilling its social equity mission. Ms. Roy's testimony is not discussed in the removal decision at all. It's conflicting evidence. The treasurer was required to address that, and she did not. That is a problem. The next allegation is that petitioner called Commissioner Camargo and another person at the commission buddies. There was no evidence of how many times this statement was allegedly made. And the evidence is that they were friends.
But there were multiple.
There was no evidence in the record that it was the amount of times. The investigator never asked. She never asked her, Commissioner Camargo.
Not a precise number, but there is evidence that it persisted in the face of objection.
I don't know if I'd agree with persisted in the face of objection. I don't think we got a clear, we didn't hear from Commissioner Camargo at all during the hearing. We weren't allowed to compel her to testify. So all we have is her written complaint and her reported statements made to the investigator. And we weren't allowed to receive the investigator's notes to see what notes she actually took of this conversation. Anyways, the original charge said that this use of the term buddies had racial animus behind it because the commissioner and the staff member were both persons of color. Treasurer Goldberg never proved that. In fact, she said that I find insufficient evidence that there was racial animus behind their comment. But at the end of the day, she still finds that it's unprofessional, and that unprofessional conduct is gross misconduct. There's no support in the law that unprofessional conduct, even if proven, is gross misconduct like that. The next allegation is Lydia Edwards, where petitioner told Commissioner Camargo supposedly that you must know Lydia Edwards. Both Lydia Edwards and Commissioner Camargo are from Boston, live in Boston, local. Lydia Edwards is a local elected official. Her name is out there a lot, and they both work in the cannabis industry. There's evidence that Lydia Edwards received testimony from the commission that Commissioner Camargo was at. It's reasonable to believe that these two people might have crossed paths in their professional circles in doing commission work.
But again, we're circling around the same issue of deference, aren't we? Certainly, the points you're making are certainly ones that can be extracted from the record. But that is clearly not the view of the matter that the treasurer took. And so my question is, given alternate constructions of facts that avail on record evidence, what deference is owed to the treasurer's construction? One can stand as you are and point out that there are different constructions of the same facts that might be equally reasonable. You could even say they are more reasonable. But so long as the treasurer's construction is not unreasonable, is it not entitled to deference?
I don't think so, Your Honor. I don't think she's entitled to deference in this situation.
Of any kind?
Well, no, she can find facts, but the facts have to be based on.
Right, but the fact found on some of these statements is this reflects a racial insensitivity, a club-footedness, an unprofessional rudeness toward colleagues, and the like. Those were all the constructions of fact provided by the treasurer in the decision. My question to you is, what deference, if any, is owed that kind of construction?
She should not be afforded deference to statements made by people who do not testify under oath at the hearing. A lot of this evidence that she relies upon is out-of-court statements made to investigators, not under oath, that there's no cross-examination ability provided to Ms. O'Brien. And then those statements are relayed to her by the investigators. That shouldn't be afforded deference in this type of situation. These are very serious allegations. The witnesses who are complaining against Shannon are never heard from, as far as we know on the record. So it shouldn't be afforded deference when you're just reciting what somebody else said to an investigator in an internal investigation outside of the purview.
Is it your view that deference is only owed where there is an eyeball ability of the finder of fact to see a testifying witness? Wouldn't in this kind of context, when you're dealing with someone already familiar with the speakers, the declarants, and the situation, would that not also invite deference?
I don't think it's a black and white question. I don't think you can say deference is always afforded in that type of situation versus not. An issue that I think I sense from that question is that Treasurer Goldberg knows facts or knows these individuals from outside of what happened in the closed door hearing. And that's a separate issue that I'll address later. But just because Treasurer Goldberg knows Sean Collins or knows Commissioner Camargo doesn't mean she should be afforded deference in interpreting or making a decision or finding a fact over who said what and who is to believe. That's unreasonable. It should be based on the record before her, the testimony in the record, and the evidence in the record.
Right. I think that is a perfectly fair point. I guess, and I'm not making mine very well, but my question is, you can put the amount of actual disputes of fact between the parties in this case in a thimble, as near as I can see. There are very, very few disputes as to what was said, who said what was the surrounding factual context in which this statement was made or that offense was taken. The underlying facts are, to a very, very large extent, an unusually large extent, not contested. What is sharply contested are the characterizations of those facts and the construction of those facts, what those facts signify. And the treasurer takes, obviously, a very, very dim view of what the making of this statement or that by a person in this kind of position means. My question is that a finding of fact to which deference is owed, or is it something very different?
If you're asking of her characterizations of the facts that she found, calling them extreme, inexcusable, flagrant, disrespectful, unprofessional, I don't think that requires any deference from the court.
Okay. You're saying those adjectival characterizations are never matters of fact.
I don't think adjectives are findings of fact. I think they're descriptors of the underlying facts. But strip down the facts, if the court is just going to accept that the facts are the facts, throwing all these adjectives in front of it doesn't help anything. It doesn't make the case that gross misconduct occurred or anything meets the standard of gross misconduct. It's a very self-serving way to say.
Would you agree that your position in this case rests very heavily on an acceptance of that proposition?
Well, I think the whole basis of the case is that these various acts, individually and collectively, don't rise to the level of gross misconduct as found in law. It's a high standard. The term gross is very significant, just like negligence versus gross negligence. It's extreme. And just to throw adjectives in front of facts that are found, which don't even look at all the evidence, or don't do an analysis of credibility versus one person said this and somebody else said this, it's hard to get behind that decision and said that the facts were found properly. The way the decision is written, it's very one-sided. Shannon's evidence was disbelieved in most instances, and the evidence that was found, or the facts that were found or believed, were all against her. Disbelief of evidence is not evidence to the contrary. There has to be an affirmative finding, there has to be a burden of proof met by the treasurer that she found these facts and they're proper. But just saying that something is extreme or flagrant, it's the eye of the beholder, and that's not the standard under gross misconduct we submit to the court.
Thank you.
I think I was on Lydia Edwards. I'll rest on that one, Your Honor. The next one is announcing Sean Collins' parental leave and resignation. And I won't belabor the facts because the court is very familiar with it. And the court has previously, in the motion to impound decision, already said that dates of absence associated with parental leave are not confidential or designated to some protection. But the real issue that Treasurer Goldberg found is that Shannon announced Sean Collins' resignation to embarrass and humiliate him. And there's no evidence to support that. The evidence was that Shannon was concerned about the commission. There was a lot of issues going on. High-level positions were vacant. They were behind on social equity regulations. They were under a deadline to finish regulations. And then the executive director comes and says, in 2 business days, I'm going to be out for 10 weeks on leave, and then I'm going to resign afterwards. I talked earlier about how the commissioners have a duty to appoint an acting executive director in such an absence. That's what she was doing. The only evidence was that she was concerned about how the commission would operate during his absence. And she was trying to find a new executive director. He had been talking about resigning for, at that point, over a year. But there was no progress made towards finding a replacement for him because he couldn't decide whether to stay or to go. So she made the announcement in a public meeting. She had a good faith basis to do that. She was concerned about the commission. But Treasurer Goldberg instead says, no, I disbelieve that. I find that you were intending to humiliate Sean and embarrass him. But there's no support for that. That's just her view of the facts. But there's no factual support in Tracy Spruce's report that Shannon was trying to hurt Sean at any point. He may not have received the comments well, but there's no intent finding, and that is what is required under gross misconduct. But putting that aside, how is a commission supposed to operate when the executive director just leaves for 10 weeks? The executive director has broad powers to sign checks, to manage the staff. There's 150 people, 150 employees at the agency at this point, and he's just going to be gone. And Shannon is handcuffed by the open meeting law. She can't talk to her commissioners about it. So she did it in an open session as she's required to. The performance, that's what this was about. And that's what she did. But Treasurer Goldberg says, no, you shouldn't have done that. You shouldn't have embarrassed Sean. You ruined his career. Tracy Spruce said he gets to define the terms by how he leaves the agency. There's no basis in law for that. He's an at-will employee. He serves at the pleasure of the commission. But the point is that she was concerned about the commission. That can't be lost on us, but it was lost on Treasurer Goldberg. The next is that she caused Mr. Collins to fear he could not exercise his leave rights, even though he ultimately exercised everything. Again, this is all about Sean Collins' subjective findings, subjective feelings. But at the end of the day, he received everything he was entitled to. And Shannon never pressured him not to take it. She wanted him to take it, but she wanted to know when he was going to take it, so how to figure out how the commission would operate. When he left in June.
Well, the suggestion of the pressure is, as seen by the treasurer, the none too subtle reference to a much shorter length of her own career.
She was trying to explain to him how hard it is to be a new parent and working at the same time. And he took it the wrong way. But there's no intent that she was pressuring him to not take the leave. She wanted him to, but she wanted to know how the commission was going to operate while he was out.
Tomato, tomato.
I disagree, Your Honor. She's has responsibility and supervision over the commission, statutory, and she's trying to figure out what he's going to do so they can plan accordingly. When he left in June for 2 weeks, he didn't tell the commissioners. He didn't tell her. She didn't know what was going on. 2 weeks is a short time in the grand scheme of things, but 10 weeks is a much longer time. That coupled with the fact that he's not going to be returning afterwards. She has to be able to plan. She has to be able to talk to the commissioners. The next one is a single isolated incident of yelling at Mr. Collins when she was upset with him about how the press team at the CCC handled a story early on in her tenure. Yeah.
Her connection to the licensing.
Correct. That the CCC would not back her and say that she didn't have any affiliation anymore, that she disclosed it to the treasurer, and that it was found that she had distanced herself through the proper measures months before that. She couldn't have been appointed the commissioner if she had an active license with the CCC. Nonetheless, yelling at somebody one time cannot be gross misconduct. It cannot rise to the level of extreme and outrageous conduct that shocks the conscience. It's the workplace. Things happen. It would be impossible to proceed if getting yelled at one time means that your appointing authority or your boss committed gross misconduct. People would be filing HR complaints left and right, and we'd be having these removal decisions over 3 commissions all the time. It just can't be that yelling one time at somebody is gross misconduct. The last is the blunt.
It's a brick, as they say.
Well, I'll address the bricks of misconduct argument in a second, if I can. But the blunt instrument comment is the last one. Again, Mr. Collins reports to the commissioners. The chair is responsible for making sure that he's doing his job. If he's not doing his job, then he can be terminated. But if he does do his job, he can stay. But using the term blunt instrument is not threatening him in a physical way. It's just telling him what the reality is. If you don't do your job, then you're going to get let go. That happens in any workplace. The use of the term is perceived negatively by Sean Collins, but it ignores the evidence that Shannon was telling him, I'm trying to help you, but you have to decide what to do. Your inaction is hurting the commission. And Tracy Spruce found that too. She said that Sean wouldn't commit one way or the other, and it was hindering the commission's plans. But again, a single isolated incident of blunt instrument does not rise to the level of gross misconduct. And to address the bricks argument that different incidences that are unrelated can form the bricks of a wall of gross misconduct, I don't see any basis in law for that, Your Honor. The cases cited by the treasurer are not remotely similar to the facts here. But even then, there was a common course of conduct by a nurse before the registration board who had engaged in certain acts, I think across 9 separate counts, that were all substantially similar. He would enter the bathroom with a male nurse would enter the bathroom with a female patient, and that violated various regulations and rules of the profession. But the point is that there's a common course of conduct here, and that was not proven by Treasurer Goldberg. She didn't say how the blunt instrument, the yelling, all the other incidences are commonly related. She tries to say that they all show that Shannon's a poor manager, but that's not supported. That can't be that you can combine all acts to find gross misconduct. There's no basis in the cases cited for that, nor in the statute. The second ground for removal is that she was unable to discharge her duties as the chair. Unable to discharge duties, that specific language, in the context of the 25th Amendment, refers to disability. There's no case cited by the treasurer that it means she can solely determine that her appointee is unable to discharge the duties as chair. And the court in Levy said exactly the opposite. It's an independent agency. The independence is important. It's supposed to be freed from the winds of politics. The appointing authority is not supposed to be the ultimate employer, the ultimate arbiter of the employee handbook or the code of ethics. Because if so, then the standard can always be met by the appointing authority if they decide that somebody's not doing a good job. It would destroy the independence of the agency and the whole purpose of the statute and the 5 separate grounds for removal.
It's a blended determination, right? The statute invests the treasurer with the authority to make a removal decision subject to a governing standard.
Correct, 5 very specific grounds. Well, the grounds aren't defined really in law or in the statute. But going back to the Levy case, the SJC talked at length about the importance of the independent agencies and how in a different case like Flomenbaum, where the chief medical examiner reports directly to the cabinet of the governor, and the governor has oversight over it, poor performance can be the grounds for removal there. But that's not what applies to this situation. It's 5 specific grounds. So just finding that unable to discharge duties means, in my view, you're not doing your job right. It would render it meaningless. anything could happen where the appointing authority says, I don't like how you handled that. I think you're unable to discharge your duties, and tie it to something in the handbook, which they should have no oversight of at all. Going to the hearing procedures, Your Honor, I'll start with the burden of proof. Below, the treasurer argued that there was no burden of proof for her, that Ms. O'Brien had the burden of proof. Now, in her brief, she says that her prosecuting attorneys did have the burden of proof, and they met that. And now the burden has shifted to Shannon to prove on appeal that there's not substantial evidence to support the findings. It's patently unfair for somebody to walk into a hearing and not know who has the burden of proof. Who has to prove what, and what is the standard? The standards were not defined prior to the hearing of what gross misconduct is, or what the 4 separate grounds for removal were. Because the final notice charge that was provided listed 4 separate grounds under the statute, everything except a felony, and handed us 44 pages of single-space reports and said, these are the grounds. Here you go. Figure out what charge applies where. But the point is that it was unfair to walk into the hearing and not know who had the burden of proof. It's very tough to prepare for that, to present what evidence for what specific charges, and proceed that way. And here and now we get a concession that the treasurer did have the burden of proof, and her prosecuting attorneys met that by the preponderance of the evidence, because that's the standard that applies at administrative hearings, according to them. I briefly touched on the fact that Treasurer Goldberg should not have presided over the hearing and made the ultimate findings of fact. We never took the position that she could not make the ultimate decision under the statute.
That would be kind of hard to do.
Well, you can have someone find the facts and then present those finding of facts to the appointing authority, and then make the ultimate determination, right? In regular 30A appeals, there's a hearing officer, they write a decision, and then it goes to somebody else who makes the ultimate decision, as far as I understand. But here, Treasurer Goldberg should not have acted as the finder of fact. She was not impartial. Her ties to Collins.
Now, this aspect of your argument has been made before, correct?
On a different record, yes.
Right, agreed. Different record at the preliminary injunction stage.
There was a much different record before Judge
Essentially
Squires.
the same sort of suite of argument, constitutional arguments was made to Judge Squires-Lee in this court.
Correct, Your Honor.
Made again to the single justice, Justice Hirschfang at the appeals court.
Correct, Your Honor. Again, on a different record.
And indeed, many of these arguments trace to arguments that were made in Levy to Justice Graney in that case.
I think the facts of the Levy case are a little bit different than here, Your Honor.
And in fact, the full SJC ultimately abjured addressing any of these issues.
Correct.
So you're certainly right that it's an open issue. The fact that I'm citing judges that have seen it a particular way, I agree, doesn't answer the question definitively. The SJC, as a full body, may see it very differently. But that's your position, I think.
Correct, Your Honor. Additional facts that came out during the hearing is that required Treasurer Goldberg to recuse herself are one, that she installed Mr. Collins in his position when he came from the Treasury. The former Chair Hoffman testified that he received multiple calls from her office to put Sean Collins in that position, despite him having no management experience. And the statute says that the executive director shall have experience in management.
But you're fighting the statute now. The statute does invest the treasurer with this authority.
Right.
Unless your position is the statute, as applied in this context, is unconstitutional.
I'm not saying the statute is unconstitutional. I'm saying that Treasurer Goldberg is not impartial because of the evidence that we produced at the hearing. One, that she put Mr. Collins in that position. She had a vested interest in ensuring that his reputation was protected because she knows that they are both tied to each other. He used to work for her. He set up the CCC with her former deputy
But
secretary.
the treasurer is an appointing authority under the statute and oversees the operations of the CCC. It's always going to be the case that there are going to be
Well, why does the appointee?
accusable biases in that context, aren't there?
For appointees, yes, but Sean Collins is not an appointee of the treasurer. He's an appointee of the commission.
Right, but the larger principle, I guess my concern would be, if this becomes situationally challengeable on the kind of ground you're arguing, the statute ceases to make sense. You have to have a completely different apparatus for addressing the rule.
But I think the difference is, Your Honor, is that when the appointing authority is deciding whether to remove their appointee, or a joint appointee is the alternate situation here. We're dealing with a situation where the chief complainant, the one whose credibility and veracity has to be determined, has close ties to the appointing authority. I don't think that situation is always going to apply, because there, in the future, if this happens again, there could be another executive director or another staff member that lodges complaints. But you have to determine on a case-by-case basis if the appointing authority has ties to that complaint. The link in the middle is the appointee, sure. And there's always going to be, well, you put that person in that position. But here, the situation is much different. It's Sean Collins having a close relationship with Treasurer Goldberg.
It's that case-by-case basis that would worry me. In other words, you're introducing a whole layer of litigability as to the most basic proposition in the statute, namely that the treasurer makes the decision.
What we're talking
Based
about,
on a standard, based on a set of procedures.
we're talking about the treasurer acting as the fact finder to determine a complaint by somebody that she's close with and somebody she's more favorably inclined to side with. That is the issue. It's a subjective and objective standard, Your Honor. Actual bias is not enough. It also is the appearance of bias. What would the public think? Would the public think, viewing the facts, that Treasurer Goldberg was impartial? And I don't think so here. There's evidence that Sean Collins' demand letter has multiple references. The demand letter that went straight to Treasurer Goldberg has multiple references to removal under the statute. That was what the design was all along. He was trying to get her removed. And we don't know what conversations that Sean Collins had with Treasurer Goldberg or her deputy, because we weren't allowed to compel her to testify. But her counsel conceded that she knew some of these things that weren't in the record. That's a problem. How can the judge, the finder of fact, know facts that aren't in the record from one of the witnesses through direct conversations with them? That's
You would agree, I take it, though, that constitutional due process does not, forensic discovery type procedures of the type you're now complaining about.
If I could ask a question, what do you mean by forensic discovery?
Well, for example, you mentioned this morning the inability to compel the appearance of a witness, that kind of subpoena authority, the inability to access the notes of an investigating lawyer. These are all things that might avail in the context of litigated discovery in a civil lawsuit, but that have never been required as a creature of constitutional due process, have they?
Well, due process is flexible as the situation demands, Your Honor. I think of the Morrison case. In 30A, General Law Chapter 30A, provides this type of subpoena power and the ability to compel witnesses. So I think it does apply. I'll agree that in a lot of the cases, it doesn't. But based on this case, based on this facts, and these laws, I think it should apply.
It does by statute, but not by constitutional compulsion, which is really what you're arguing now.
Well, the Stetson case says due process requires the ability to cross-examine witnesses, right? That didn't happen here. We got to cross-examine the investigators.
You got to cross-examine the witness.
We got some witnesses, but not all relevant witnesses. We weren't asking to cross-examine every single person at the CCC. We had a finite list. The complainants, Collins, Camargo, and the people who were in tune with the facts, Treasurer Goldberg and Deputy Treasurer King. So I think the situation here does require that type of ability. Due process does require that. Because at the end of the day, the facts that are found are not based on all the facts. And even in the civil trial, you can't get at all the facts. But there are relevant facts here that we weren't allowed to get in. We had no ability to. The CCC and the treasurer worked in tandem throughout this. The CCC gave Treasurer Goldberg Tracy Spruce's report in December of 2023. We didn't get that until March. The treasurer and the CCC prepared the investigators for the hearing. Both of them met separately with the treasurer's counsel to prepare their testimony. There was the ability for them to get these witnesses here. We should have had the ability to subpoena them, but we weren't able to. But there was still the ability to get them there and to hear from them. And wouldn't the treasurer want to hear from all these witnesses, to make a decision based on the facts, to assess the real credibility of the witnesses, not just read an investigator's report and fine? Another issue is the notice of the charges. I touched upon it briefly. We got a letter in October that laid out some allegations from the first report and Treasurer Goldberg's observations of the July 28th meeting. And that was the initial grounds for it. Later in March, prior to the hearing, 15 business days before the first day that the hearing was supposed to start, we got a separate notice that listed 5 bullet points and said, I'm going to rely on the investigators' reports and that it might meet the standard for 4 separate charges under the statute. That is not specific notice. We were left guessing at what conduct applies to what. What charges is she going to proceed on? Some of the investigators did not find that the initial allegations of Sean Collins, they found for Shannon. For example, Sean Collins claimed that Shannon caused him to begin to think of resigning from the commission. That was simply not true. There's evidence that he was thinking of resigning prior to that. But how are you supposed to handle that if you don't know what facts apply to the specific charges? It's impossible. Even to this day, she only found for 2 of the charges. But she doesn't link up the initial notice. I talked about the Commissioner Camargo allegation of buddies. That was initially presumed to be in the charges for racially insensitive conduct. But then the finding was that it was unprofessional conduct. And that was gross misconduct. So even when you win, you still lose because she finds against you. The point is that you're just guessing at the end of the day.
Counsel, you are approaching roughly the halfway point. I don't want to rush you too much, but I want to make sure that we have left enough time for the other side.
I was just about to conclude, Your Honor. Thank you. Your Honor, there's not substantial evidence to find that Shannon committed gross misconduct or is unable to discharge duties. Looking at the whole record, we've cited, I'll rely on the briefing, but we cited the contrary evidence that detracts from the findings and how the credibility assessments weren't made. So at the end of the day, I've asked the court to vacate the decision and reinstate Ms. O'Brien as the chair. Thank you.
And in terms of the remedy you seek back pay for the 1 year of non-payment plus benefits,
Correct, Your Honor.
reinstatement for the remainder of the term,
Correct, Your Honor.
which is give or take 2 years,
My math is right, yep. Yes, Your Honor.
and you agree that interest, if there were such an award, not available.
I don't know if I can commit to that one yet, Your Honor. I have to look at the cases. Candidly, I don't know if interest applies enough to back pay. I would presume it does not, but I'd like to confirm first.
Because the treasurer is sued in her official capacity as the Commonwealth.
Correct, Your Honor.
There. Thank you.
Thank you.
Ted?
Good afternoon, still good morning, Your Honor, especially good afternoon. We are going to rely principally on the writings, our submissions. The court is very well familiar with the record of this case, obviously, and with the written briefs. And I'm happy to answer any questions that you have on specific points, but I don't want to spend a lot of time rehashing things that are comprehensively briefed in writing, and my, I'm sure, oral presentation will not add anything to those arguments. I will note this, Your Honor, is that the
Humility with which we are not familiar in these precincts.
in this case, the treasurer's decision is a 73-page decision, which is very thoughtful. I sat down last night and read through it yet again in terms of its comprehensiveness and the fact that in making her factual findings, she doesn't agree with her prosecuting attorneys on various issues, and she agrees with Commissioner O'Brien on certain factual issues. So what the treasurer's decision shows is that she went through this record looking at everything before her. She weighed things carefully. There were points where there were inferences for her to draw or to decide, and reasonable inferences were drawn, and she explained the inferences that she was drawing. So a few moments ago, when the discussion was going on here relating to the use of adjectives in the treasurer's decision, many of those adjectives are inferences. That's the power of the treasurer in this administrative proceeding to draw inferences from the evidence. And where she does draw inferences, she explains why she's drawing the various inferences. When she's making credibility determinations, she's explaining why she's making various credibility determinations.
So let me pause you, Mr. Hitt. Don't lose your train of thought. You've addressed, or you've started to address something that's been nipping at my ankle the whole case, and that is, what is the level of deference, if any, to which the treasurer's decision is owed when she makes conclusions like this was a flagrant transgression, a shameful piece of insensitivity, an outrageous act toward a colleague, and so forth. Are those characterizations of the underlying facts segregable from the facts themselves? Are they necessarily part and parcel of the facts? Or viewed differently, are they really legal conclusions masquerading as fact? That really, when you say something is flagrant and unacceptable and unprofessional and whatever other breathless word you want to attach to it, are you really not, in effect, making the legal conclusion, understanding that this is how gross misconduct is defined in the cases?
Well, Your Honor, I think the answer is some of the adjectives that are used are inferences that she's able to draw, she is drawing, into which deference is owed to her, so long as they're not unreasonable inferences. Here, what you're getting to, I guess one way to organize it, Your Honor, is there's very clearly in this decision a factual findings section, and the things there need to be factual findings. When things are being discussed in what is in essence the legal conclusions sections as to gross misconduct and unable to discharge the office, the discussion of the facts there in the context of the legal conclusions, and she's then explaining.
There's no question that structurally the characterizations of fact that I'm referring to appear in the factual section of the decision. I have to assume that's advised. The treasurer understands full well that factual findings will get some measure of deference and legal conclusions will not. Everybody agrees that as a matter of black letter law, it is thus. But my question is, in smuggling in those characterizations into the factual section, is the treasurer truly doing what you suggest, simply drawing inferences about and regarding fact, or is she simply attributing degree of wrongfulness to fact, which is, in the final analysis, the ultimate question?
I believe she's drawing inferences, Your Honor, that she is lawfully able to make in her decision-making process. She has to view the facts and reach conclusions, about what a fact is and what it's showing and what degree of, in her sense, what degree of, what inference she sees, how she sees it as the fact finder, which the statute requires her to be. So, backing up again to the statute here, it's written notice of the charges and an opportunity to be heard. And beyond that, there's no great guidance in this statute about how she's supposed to apply or define what is gross misconduct and what is unable to discharge the duty of the office. The other two, I think two of the other three factors are much easier to interpret because they require a felony conviction, or they require things that are very obvious. But as to these two, it's less clear. So I think here the treasurer was trying to very clearly map out as clearly as possible for whoever was going to review her decision what the facts were, what the inferences were she was drawing, why she was making various credibility determinations, and then turn to the statutory charge, applying the statutory language to the facts before her. Now, this court may disagree with her inferences, but that disagreement isn't something that permits the court to substitute its view of the facts for the treasurer's view of the facts. That bridge is only crossed if you conclude that it was an unreasonable inference. If you look at the totality of the record and say, yeah, there is absolutely nothing here that would support the treasurer making that finding of fact or conclusion of law. So there's room for you to exercise your authority, but it requires a very clear showing that the treasurer is way off the reservation based on.
Let me ask you this, Mr. Hitt. Don't lose your train of thought again. Would you agree that the robust independence with which the legislature sought to invest the CCC calls for an especially exacting standard for removability?
No, I think we look specifically to the statutory language, and the statutory language is what the statutory language is.
But you don't think, as suggested by the SJC in Levy 2, that an important piece of the context to construing that piece of undefined statutory language is this matter of agency independence?
I hesitate to draw too many lessons from the Levy 2 case because of the unique facts of that case involving the big dig and the very pitched political battle that was going on at that point in history relating to the big dig and what was very clearly concerns about policy positions being taken by authority members that clearly the governor was unhappy with. So Levy 2, yes, it stands for certain propositions, but I'd be careful reading it too broadly here. The crux of the issue in Levy 2 was at that point in time the governor was arguing that even substantial evidence shouldn't apply to the removal decision, that the certiorari standard should just have been abuse of discretion. And the governor lost on that point in a decision that is not clearly reasoned by the justice who wrote the decision, but it is now the law of the Commonwealth. So we sit here today now applying the substantial evidence standard rather than just an abuse of discretion standard. So,
well, speaking of Levy 2, would you agree that the 2017 amendments to this statute, which came in the wake of Levy 2, that resulted in the dispensing with the standard that was applied in Levy 2 under Chapter 30, Section 9, and replacing that standard with something very, very different textually, the inclusion of qualifiers like substantial neglect of duty, gross misconduct. Is there any way for me to interpret that other than as a reflection of the legislature's intent to significantly tighten the standard of removability?
Yeah, I think, Your Honor, it tightened, perhaps, but significantly tightened. I don't think it's necessary.
The difference between misconduct and gross misconduct?
But Your Honor, it's not in the legislature did not define those terms, left it to the treasurer to try and figure out what the heck they meant, and that's what she's done here. She's carved a very straightforward path that looks. Okay, was there case law? Okay, she finds the one decision, the Board of Registration of Medicine case. She adopts that language. She looks at Black's Law dictionary definitions of gross misconduct. She looks at the available federal case law, the Judge Ponzer case, she pulls it together and then takes that legal standard, which, by the way, plaintiffs don't challenge here, and she applies it to the facts of this case. Here, there are challenges to whether there's substantial evidence to meet the standard that the treasurer adopted. We're not here, they're not arguing, they've waived the argument that the wrong standard of most gross misconduct was applied. When we turn to the second issue of unable to discharge the duties of the office, the duties and powers of the office, there, again, plaintiffs rely principally on the 25th Amendment, which is clearly not the standard here. It is not a.
Why is that clearly not the standard?
Because
it's the most well-known removal provision in American law, and the legislature essentially uses the language of that standard for its own removability provision in the CCC statute, and yet we're to conclude that they intended a dramatically different intent?
Well, Your Honor, there's no case law on the 25th Amendment, so the language just stands there as constitutional language. Here,
A lot of prevailing scholarship.
well, scholarship, but plaintiffs here then look to physical disability as the standard, and when you look at Massachusetts law, when the legislature wants to make disability the standard, they use the word disability.
The reason that there's so little case law is that one might suggest that the meaning of the term unable to discharge duty does not mean performance failings that lead a decision maker to conclude that the person's not up to the job, but instead means something much more exacting, like physical incapacity.
Well, yes, Your Honor, it might, but again, the legislature didn't state it that clearly, and they left the interpretation of the statute to the treasurer in the first place, and she adopts a very reasonable interpretation of the statute and of the language, and then applies it to the facts before her. And again, if the legislature had intended such an exacting standard, they could have clearly defined the term.
Doesn't the treasurer's interpretation of unable to discharge, though, essentially revive the for-cause standard of Chapter 30, Section 9 that had been specifically rejected?
No, I don't think it does, Your Honor. And that's not an argument that's raised by plaintiffs, and that, taking a step back for a moment, again, the unable to discharge language here is being implemented, or it's being invoked in a context where the overarching statutory structure puts this focus on social equity and in helping communities that have been traditionally punished by the criminal justice system by cannabis-related criminal enforcement, and providing opportunities to allow those impacted communities to be part of the equation. So here, in deciding that unable to discharge the duties and powers, the duties and powers refers in part to that overarching statutory goal on the social equity part of this, which then again informs the treasurer's view of why the conduct here was of a kind and quality that wasn't just.
She's unable to do the job because she wants to use the term yellow to refer to persons of Asian national origin?
Your Honor, it wasn't one instance, it was many instances that she viewed in combination. So had it been one instance, it would be a different case. But here, the record indicates various instances which were viewed in totality. So with that, Your Honor, unless you have other specific questions, we ask that the treasurer's decision be affirmed and the judgment enter for the treasurer in this case.
And just a couple of smaller questions. How, in your view, did Chair O'Brien flagrantly interfere with Sean Collins' parental leave rights?
Flagrantly interfere?
I think that was the finding of the treasurer. How exactly did that occur?
Yeah.
Given that he took his
again,
leave, was not prevented from taking his leave, was not punished for taking his leave. She brought up his leave in a meeting. How's that a flagrant interference?
Well, it's flagrant in the sense, as the treasurer explains, that it happened. It was an intentional decision of the treasurer to raise it at the meeting and to put Sean Collins on his heels publicly on an issue that is a personnel issue in terms of his taking any type of medical leave. It was done publicly on the record at a meeting. I believe the date was July 28th, 2023, and she the day before, clearly, asked Sean Collins if he had anything to announce, and then the next day when he hadn't taken her up on that, she flagrantly raised the issue and took items out of order and raised it publicly with the other commissioners. Now, that's set forth in the treasurer's decision, and the treasurer goes on to explain the other, I believe, the other reasons why she drew that conclusion.
And I struggle to understand the exact nature of the violation that raising the matter at that open meeting gave rise to. Are you suggesting that raising it as she did, raising the leave issue as she did, itself violated the open meeting law?
Your Honor, the open meeting law is not an issue in this.
Well, it is in the sense that the treasurer asserts that either the open meeting law required or at a minimum permitted this matter to be taken up in executive session.
Yes.
So, is it your position that the open meeting law either required or permitted that?
Yes.
If so, which one?
I believe required, and it.
I'm not sure it even permits.
Well, Your Honor, it's a personnel issue regarding someone taking medical leave. So, raising it.
It's a personnel and performance issue.
But raising it was a performance issue. It's not a performance issue when someone seeks to take family medical leave. That's not a performance issue. So what the treasurer was
it's a policy issue. Do we need to hire a replacement?
Well,
can this agency function for 10 weeks?
Yeah.
Without an executive director?
Again, Your Honor.
Something the statute itself addresses.
But again, Your Honor, it was raised in a way to try and pressure Mr. Collins from taking his leave or exercising his leave or being punished for exercising his leave.
That's a strong inference that's hard to find in this record.
Well, that is an inference that was drawn. And,
Well, that I agree with. What I'm saying is it's an inference that's hard to ground in the record.
Well, I think the treasurer explains how she grounds it in the record in terms of the fact that there had been multiple conversations between Mr. Collins and the chair regarding the leave issue and when he might take it, and the birth of his child, all of which informed the chair when she decided to publicly raise the issue at that meeting on the 28th. So it's there in the record. The treasurer explains why she draws the inference that she does.
And is it the treasurer's view, this was also hard to tease out of the decision, that this somehow invaded Mr. Collins' privacy? That this might violate chapter 214, section 1B, or some such thing?
Well, I think his statutory. I think anytime you're exercising medical leave, yes, there's a zone of.
He's not exercising medical leave.
Family medical leave, FMLA leave.
His spouse is having a baby. This is not something that was going to be secret. This was not, he's going in for some private surgery. He needs to take some time off. Family's having a baby. This is not a matter of private. In fact, it was inevitably going to be known, sort of root to branch, in a short time. Is the treasurer's view that this is that the raising it in the way Chair O'Brien did implicates a violation of substantial privacy interests?
I don't think the treasurer uses that exact language in her decision, Your Honor. I think she refers to the statutory bases for taking the privacy, or taking the family leave, and the fact that in a government context, that's usually, you might see that someone is pregnant, or you might understand that someone's spouse is pregnant, but when someone takes leave and it's not publicly announced that this is their family medical leave is legal.
Except when they happen to be the operative head of a public agency.
Yeah, but there are many operative heads of public agencies who take leave without it being used in a way that seems to put pressure on them for taking the lead, right, or attempting to take the lead. And my memory is that is the statutory language that's referred to in one of the footnotes makes reference to the fact that it's the taking of leave or attempting to interfere with taking the leave. So it's kind of like the State Civil Rights Act, where it's interference or attempt to interfere with particular civil rights. It's the same statutory structure.
Thank you, sir.
Thank you, Your Honor.
Appreciate the argument.
I may-
Do you need the last word?
If I may briefly, Your Honor, it's not required to go in executive session for the discussion of professional competence. It's required to be discussed in open meeting, the professional competence. In 30A, Section 21 says a public body may meet in executive session for the 10 separate reasons. So it's permissive, it's not mandatory. Just briefly, Your Honor, in the
Provided that there's predication for
48
going into executive session asserted on the record.
Right, and 48 hours notice to the person who's gonna be discussed, and I'm not the one well versed in that, but I know enough that it's not mandatory, as we just heard. We also heard that there's no case law interpreting the language unable to discharge duties, certainly in the context of the 25th Amendment, but in our reply brief, we cite a case from Indiana where the Supreme Court and the state representatives applied that specific language, unable to discharge the power and duties of office due to the person's medical condition. So there is support in law.
There are 2 or 3 states that have adopted similar kinds of unable provisions into their removal.
Correct, Your Honor. But I think just specifically that case is the only case that really discusses the language at length, as opposed to the scholarship that we've cited, and I'm sure the court is aware. Finally, Your Honor, I think we heard that we didn't argue that the levy 2 case of the for-cause standard does not apply to the unable to discharge duties element of the statute. And in our brief, we've expressly referenced that same argument, how levy 2 makes it so it's a decision that is not entitled to deference, and it's not over policy disagreements or what the appointing authority thinks.
Converts it to a no confidence.
Say it again? Converts
Converts it to a no confidence.
Certainly, Your Honor. Other than that, I rest, Your Honor. Thank you.
Very good. Thank you all.
Court, all rise. This court is now in recess.